There are two special civil actions mentioned in your rules of procedure for environmental cases. The first is the writ of kalikasan and the second is the writ of continuing mandamus. What we will be discussing in this video is the writ of kalikasan. So in your writ of kalikasan, what you have is a petitioner. Since this is a special civil action, you call him a petitioner. But in your ordinary environmental case, what you have is a plaintiff. You call him plaintiff. And for him to start an environmental case, he needs to file a verified complaint. And in his complaint, dapat naka-indicate ang names ng parties, their addresses, the cause of action, the reliefs prayed for, and also include or attach all evidence that would prove or support the cause of action. That includes the affidavits of your witnesses, and if you have object evidence, isama na, then documentary evidence. Also include or state in your complaint that it is an environmental case, and you state also the law involved. Kasama din ang certification against forum shopping because that is an initiatory pleading. But in your writ of kalikasan, what are you going to file? The petitioner will file a verified petition. Ano ang laman ng verified petition? Answer is more or less the same with your verified complaint. You have to indicate the personal circumstances of the petitioner as well as that of the respondent, and then you have to include also the environmental law or rule or regulation violated. You have to attach all the relevant and material evidence that would consist of the affidavits of the witnesses, the documentary evidence. If there are scientific studies or other expert studies, isama na pati ang object evidence. Samahan mo rin ng certification against forum shopping, and the relief will include a prayer for the issuance of a tipo. Let me just emphasize that in the verified petition for writ of kalikasan, you really have to indicate the environmental law, rule, or regulation violated or threatened to be violated. And then you indicate also the act or commission or omission complained of. And lastly, take note, ang ginamit ng batas is and the damage, the environmental damage. But take note, ano ang requirement ng batas when it comes to environmental damage? It must be of such magnitude. It must be of such magnitude that it will prejudice the life, the health, or property of inhabitants in 2 or more cities or provinces. Bakit? Because again, you go back to your section 1 of your rule 7. What is the nature of the writ? This writ is available only. This is a remedy that is available only if there is a damage, if there is an environmental damage. But the requirement again of that damage is that it must be of such magnitude that it will prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. Ini-emphasize ko yan kasi yan ang lumalabas sa bar questions. In your ordinary environmental case, who is your plaintiff? And in your writ of kalikasan, who is our petitioner? Answer is, here in your ordinary environmental case, the plaintiff is any person who stands to be benefited or injured by the judgment of the suit. That is your real party in interest. Just take note though that the real party in interest includes the government and juridical entities authorized by law. Also, in your ordinary environmental case, any person or any Filipino citizen can file a case as long as he is representing the minors or generations yet unborn. That is called the citizen suit. How about in your writ of kalikasan, who is your petitioner? You have the natural or juridical person, the entity authorized by law, or the people's organization, NGO, or any public interest group. What is the requirement when it comes to people's organization, NGO, or any public interest group? The requirement is they are accredited or they are registered with any government agency, and they are filing that writ of kalikasan on behalf of persons whose right to a balanced and healthful ecology is violated. Bakit inaalaw ng batas itong mga people's organization or NGO or any public interest group to file? Because you go back to your 1987 Constitution, Article 2, Section 16. This is a state policy that the state shall protect and advance the right of the people to a balanced and healthful ecology. So, in what court are you going to file your ordinary environmental case? Answer is in the MTC or in the RTC. How about your writ of kalikasan? Where are you going to file that? You can file that in the Court of Appeals or in the Supreme Court. Basis, read Section 3 of your Rule 7. The petition shall be filed with the Supreme Court or with any of the stations of the Court of Appeals. 2018, number 21, bar exam question, tingin agad sa tanong, is the petition within the jurisdiction of the RTC of Cebu? What petition are we referring here? It's a petition for writ of kalikasan. So without reading the facts, you can already answer because Section 3 again is very clear that if you are going to file a petition for writ of kalikasan, sino lang ang may jurisdiction? Supreme Court or any of the stations of the Court of Appeals. Let's go now to the rule on filing fees. In your ordinary environmental case, the payment of filing and other legal fees by the plaintiff shall be deferred until after judgment. It shall constitute a first lien on the judgment award. How about in your writ of kalikasan? Masyadong malaki ang difference because in your writ of kalikasan, the petitioner is exempted from the payment of docket fees. So in your ordinary environmental case, after the filing of the verified complaint, the court now, the environmental court, either the MTC or the RTC, will issue summons. And who will serve the summons? Answer, sheriff, deputy or other proper court officer, the counsel of the plaintiff or the representative of the plaintiff, or any suitable person. And how do you serve the summons? Answer is personal service, substituted service, or summons by publication. How about in your writ of kalikasan? After the petitioner files his verified petition, what will happen next? The court will issue an order. The court shall give an order if the petition is sufficient in form and substance, issuing the writ and requiring the respondent to file a verified return. And who will issue that or who will serve that order? Answer is the court officer or any person deputized by the court. And how do you serve that order? Answer is personal service or substituted service. So when the court now issues the summons, what are the options available to the defendant? Take note that your defendant cannot file a motion to dismiss. And ang motion to dismiss, walang qualification. Kahit anong ground pa meron ka, hindi ka pwedeng mag-file ng motion to dismiss. Defendant cannot also file a motion for a bill of particulars. So ano lang ang pwedeng i-file ni defendant in your ordinary environmental case? He can file a motion for extension of time to file an answer as long as the period will not exceed 15 days. He can also file his verified answer or verified answer with cross-claim or compulsory counterclaim. What happens if the defendant now files his verified answer? Can the plaintiff file a reply? Answer is no, because your reply is a prohibited pleading. Reply and rejoinder, they are both prohibited pleadings. What happens if the defendant will not file an answer? Then plaintiff cannot, take note ha, plaintiff cannot file a motion to declare the defendant in default because this is also a prohibited motion. Take note also that defendant cannot file a third-party complaint. How about in your writ of kalikasan? After the Court of Appeals or the Supreme Court issues that order or give that order issuing the writ, what will happen next? The respondent, ang bola ngayon nasa kay respondent na. But can respondent file a motion to dismiss? Answer is also no. He cannot also file a motion for a bill of particulars. He cannot also file a motion for extension of time to file return. So ang option lang talaga na meron si respondent is to file his verified return. Take note ha, he has only that option to file a verified return, and his verified return must not contain counterclaim or cross-claim because this is a prohibited pleading, not allowed. After the respondent files his verified return, take note that your petitioner cannot file a reply. This is also prohibited. And if your respondent will not file a verified return, petitioner cannot declare the respondent in default. The respondent also cannot file a third-party complaint. So in your ordinary environmental case, there are 6 prohibited pleadings or motions, and in your writ of kalikasan, there are 8 prohibited pleadings or motions. Again, motion for extension of time to file return is not allowed, and verified return with cross-claim or counterclaim is also prohibited. The period given by law to the defendant to file his verified answer is 15 days, 15 days from receipt of summons. Just take note though that this 15 days can be extended because your defendant is allowed to file a motion for extension of time to file an answer. And what is the requirement of the law when it comes to your verified answer? According to the law, the defendant should attach already all evidence in support of the defense. So you attach if you have affidavits of witnesses, reports, or studies of experts. And if you have special defenses or affirmative defenses, then you have to plead that one, otherwise they shall be deemed waived, exception ang lack of jurisdiction. How about in your writ of kalikasan? In your writ of kalikasan, when can respondent file the verified return? The period given is 10 days. Just take note that this is not extendable. It is a non-extendable period of 10 days. That is the reason why respondent cannot file a motion for extension of time to file return. And the return should include, parehas lang dito sa verified answer, it should include already the affidavits of witnesses, documentary or object evidence, scientific or other expert studies. And if there are defenses not raised, then they shall be deemed waived. In your ordinary environmental case, if the defendant will not file his answer, then the plaintiff cannot also file a motion to declare the defendant in default. This is a prohibited motion. So what will happen now? Section 15 of your Rule 2 has the answer. It is the court that will declare the defendant in default, and upon motion of the plaintiff, the court shall receive evidence ex parte, and the court shall render judgment based on that evidence and the reliefs prayed for. How about in your writ of kalikasan? What happens if the respondent will not file a return? Then petitioner cannot also file a motion to declare the respondent in default. That is also a prohibited motion. But what will happen now if there is no return? Read section 10 of Rule 7. In case the respondent fails to file a return, the court shall proceed to hear the petition ex parte. The court will still proceed to hear the petition ex parte. I just want to call your attention to section 13 of your Rule 7, because if respondent refuses to file his return or unduly delays the filing of a return, then he may be punished after hearing for indirect contempt under Rule 71 of the Rules of Court. Although we emphasized already that the respondent in your writ of kalikasan can only file his verified return, take note that your respondent is allowed to file this pleading. And what is this? He can file a motion for the issuance of that ocular inspection order. But this is also true when you talk about the petitioner, because petitioner can also file this one. Any party may file a verified motion for the following reliefs. Number 1 is the ocular inspection order, and number 2 is the production or inspection of documents or things order. What is the requirement of the law? Parehas lang in these two orders. The requirement is that the motion must be able to show that this is necessary to establish the magnitude of the violation or the magnitude of the threat as to prejudice the life, the health, or the property of inhabitants in 2 or more cities or provinces. So after the defendant files his verified answer, the court now will schedule the case for pre-trial. The court shall schedule the pre-trial, and it shall set as many pre-trial conferences as may be necessary. Kaya in your ordinary environmental case, during the pre-trial, the court can refer the case to mediation, call preliminary conference or pre-trial conferences, and then it will require the parties to submit their pre-trial briefs, and the court will issue a pre-trial order. So yan ang nangyayari. And if you are going to compare that to your writ of kalikasan, what will happen in your writ of kalikasan? After the respondent files his verified return, answer is there will now be a hearing. Section 11 of your Rule 7 is very clear that the court will now set the petition for hearing. And take note of the period, ha? The hearing shall not extend beyond 60 days. And in this period of 60 days, the court has an option to call for a preliminary conference. The court may call a preliminary conference. So that is an optional. Ano ba ang nangyayari sa preliminary conference? It will, the purpose of the preliminary conference rather is to simplify the issues and to determine the possibility of obtaining stipulations or admissions from the parties. So after pre-trial in your ordinary environmental case, there will now be a trial, and after trial, the case will now be submitted for decision. After the last party has rested its case, the court shall issue an order submitting the case for decision. How about in your writ of kalikasan? After hearing, that hearing may include a preliminary conference again, then the case now is submitted for decision. Section 14 of your Rule 7, after hearing, the court shall issue an order submitting the case for decision. So after the court issues an order submitting the case for decision, in your writ of kalikasan and also in your ordinary environmental case, parehas ang mangyayari. The court may require the parties to submit or to file their memoranda. Section 14 of your Rule 7 is very clear that the court may require the filing of memoranda and the period is 30 days. Take note, it is a non-extendable period of 30 days. And that is the same when you talk about your ordinary environmental case. The period again is non-extendable period of 30 days from the date the case is submitted for decision. So what is the next thing that will happen? The court will now issue a judgment. What is the period? The period is 60 days. 60 days from when? From the time the petition is submitted for decision. So within 60 days from the time the petition is submitted, the court shall render a judgment either granting or denying the privilege of the writ of kalikasan. In your ordinary environmental case, that is also the same. There will now be a judgment and the period of the court to decide the case is 60 days. So in summary, in your petition for writ of kalikasan, the first step is that the petitioner will file his verified petition, after which the Court of Appeals or the Supreme Court will give an order issuing the writ, and then the respondent will now file his verified return. And after the return is filed, the case now will be set for hearing. The court will set the hearing, which may include the calling of a preliminary conference. And after the hearing, the court will give an order submitting the case for decision. But take note that the court may also require the parties to submit their respective memorandum. After this one, then the court now will issue a decision or a judgment, either denying or granting the privilege of a writ of kalikasan. Just take note that in your decision or in your judgment, ano ang pwedeng ibigay na relief ng court? Ito ang dapat ninyong tandaan. Sa privilege of a writ of kalikasan, ito lang ang pwedeng ibigay na relief. A relief which relate to the right of the people to a balanced and healthful ecology, or a relief that relate to the protection, preservation, rehabilitation, or restoration of the environment. Hindi pwede sa petition for the writ of kalikasan ang relief ng damages for personal injury. Hindi ka pwedeng mag-recover dyan ng damages for injury suffered. So what is your solution then? You read your section 17 of your rule 7. Ano ang sinasabi? You can file or you can institute a separate action for your civil, criminal, or admin action. You can file that in a separate proceeding, in a separate action. So if the judgment or the decision is not favorable to you, what is your remedy? What is the next step? You can file a motion for reconsideration. And if the decision of that motion for recon is still not favorable to you, what is your remedy? You can file an appeal. Or pwede din naman, diretso ka nang mag-appeal. The period is 15 days. 15 days counted from when? From the date of your notice of the adverse judgment, or 15 days from the denial of the MR. Where are you going to appeal? Obviously, Supreme Court, kasi sino ba ang may jurisdiction ng writ of kalikasan? And what are you going to use? That is your Rule 45. Take note ha, ang Rule 45, that is only questions of law. But here, exception to your Rule 45, you can raise questions of fact. The reason why I am explaining in detail the difference between an ordinary environmental case versus your writ of kalikasan is because of this 2016 number 13 bar exam question. Tingin agad sa tanong, what action will you recommend? What are the facts? You have here the officers of Ang Kapaligiran ay Alagaan Incorporated. They want to engage your services in order to file an action against ABC Mining Corporation. ABC Mining Corporation is engaged in mining operations in Santa Cruz, Marinduque. Ang problema is ABC is using highly toxic chemicals in extracting gold, and as a result, the mine tailings of ABC were accidentally released and discharged into the rivers of the town of Romblon and Quezon. Syempre, there will be damages, and damage to the crops and the loss of earnings were estimated at 1 billion pesos. Damage to the environment is also estimated at 1 billion pesos. So paglapit sa iyo ng organization ng Ang Kapaligiran ay Alagaan Incorporated, they want to ask you, attorney, ano ba ang mas magandang i-file? Is it a petition for writ of kalikasan or a complaint for damages? So what is your answer? The answer is mas magandang i-file ang petition for writ of kalikasan. Procedurally, nakita na natin, we discussed that already, that it is faster. Mas mabilis matapos yung case. But aside from that, the other advantage of filing a petition for writ of kalikasan is, number one, you will have no issue when it comes to your parties when it comes to your petitioner, because again, Section 1, your petition for writ of kalikasan is available to people's organization, NGO, or any public interest group. Ano ang requirement? Dapat lang merong environmental damage, and that environmental damage must be of such magnitude that it will prejudice the life, the health, or property of inhabitants in 2 or more cities or provinces. In this problem, definitely merong damage to the life, health, or property of the inhabitants of Romblon and Quezon. Aside from that, your petition for writ of kalikasan, you will be exempted from the payment of docket fees. If you are going to file your complaint for damages, magkano kaya ang filing fees niyan? For sure, malaki kasi ang damage here is 1 billion pesos. Also, the decision of your action for petition for writ of kalikasan is immediately executory. Just take note that the court cannot award damages to individual petitioners. The court cannot award damages to individual petitioners, but there is a solution to that, because you can file or you can institute a separate action of civil, criminal, or admin case.